So the panelists on this panel will focus on the protection of and assistance to victims of human trafficking. My name is Patty Leonard. I'm a member of the Graduate School of Public and International Affairs here at the University of Ottawa. I'm also chair of the International Migration Network, which has taken a role in helping to organize this conference for today. We have 4 speakers. These speakers have been warned and warned again that they have been asked to speak for between 5 and 7 minutes. And so once they get to 7 minutes, I will look at them angrily, and once they get to 8, I will start gesturing wildly, so they know that they're meant to wrap up their comments. We have 4 interesting talks. We'll start with Petya Nestorova, the Executive Secretary at the Convention on Action Against Trafficking in Human Beings from the Council of Europe. She'll be followed by Matthew Taylor, Counsel of the Criminal Law Policy Section at the Department of Justice. He will be followed by Adil Atak, Assistant Professor of Criminology at Ryerson University. And finally, we will hear from Elise Wolbolt from PACT Ottawa, an organization which focuses on, the acronym for which stands for Persons Against the Crime of Trafficking in Human Beings. And each of them will offer distinct perspectives on the challenges associated with protecting and offering assistance to victims of human trafficking, and they will in particular talk about the ways in which we have started to move finally away from criminalizing victims towards offering support, something that the opening panelists have also gestured towards. And so with that, I will start Petya's timer right now.
Good morning. Bonjour. I would like to join the previous panelists, first of all, in thanking the organizers for convening this conference. I'm really glad that Austria and Switzerland have once again joined forces against human trafficking. In fact, this was part of the title of the conference that we organized a few months ago in Vienna, together with the OSCE and the chairs of the 2 organizations, Austria and Switzerland. I was relieved to see that the previous moderator was not so strict on the absolute 5-minute rule, although it seems that our moderator will not be so generous, so I will be careful not to impose Canadian rage on me. But still, I will spend 1 minute just to give you a little bit of context about the organization that I represent, because there's no particular reason why you should know much about the Council of Europe, which is not the European Union. The Council of Europe is a pan-European intergovernmental organization which was set up in 1949, actually the first one on the continent, the European continent after the Second World War. And it is based around 3 pillars, human rights, democracy and rule of law. It has within itself the European Convention of Human Rights and the European Court of Human Rights, which is key to shaping up the legal framework, international legal framework for protecting and promoting human rights in Europe. And the Council of Europe's speciality as well is to produce conventions which are ratified in Europe, but some of them are opened for any country around the world. These conventions are negotiated, agreed with the experts from all the member states, then they're open for signature. And then when they enter into force, some of them have monitoring mechanisms to ensure that they do not remain dead letter, but that they effectively implement it. And one such convention is the one that I'm going to tell you about. It's the Convention on Action Against Trafficking in Human Beings, which was opened for signature in 2005 and entered into force 3 years later. I'm the Executive Secretary of the monitoring mechanism, which was set up to ensure the effective implementation of this convention. And this monitoring mechanism consists of 2 pillars. One of them is known under the acronym of GRETA, a nice female name. Don't ask me why it was chosen. It was before my days. And it actually stands for Group of Experts on Action Against Trafficking Human Beings. It's a panel, multidisciplinary panel of 15 independent experts they're basically selected on a competitive basis from the parties to the convention. And there is a more political part to this monitoring, which is known as the Committee of the Parties to the Convention, which is composed of national representatives, normally from the permanent representations of the countries to the Council of Europe, and they give the political dimension to this monitoring process. Unlike the previous speakers, my presentation will probably be a bit dry and less emotional, because I'll be basing myself on the findings from the country evaluations that Greta has carried out in the last 4 years. Basically, we have now almost completed the first cycle of evaluation of the Council of Europe Convention. And we have now in the public domain 35 country evaluation reports, 35 out of 42 parts to the convention that we currently have. I must say that this number, 42, is set to grow. I heard that Estonia is now on the brink of ratifying, and it's a convention which is also open to any country around the world. We have had interest from countries in the South Mediterranean region. Now, Canada is not, unlike the OSCE, Canada is not a member of the Council of Europe, but I understand that there is a Canadian parliamentarian delegation which is associated with the Parliamentary Assembly of the Council of Europe, and they come to the sessions there. Now, I was asked to, as the session is on protection of victims, I will focus on 3 particular aspects of the Council of Europe's Convention, which, by the way, imposes strict legal obligations on the parties in the areas of the 4 Ps. I will focus, of course, on the second P, which is protection, and in particular on the aspects of identification, which is linked to the non-punishment of victims and the provision of assistance victims. Now, how many minutes have I exhausted? Oh my God. Time is running quickly. Now, on the identification, first of all, it is obviously of fundamental importance. Many trafficked victims do not see themselves necessarily as victims. They're not aware of the legal meaning behind the term, and therefore the onus of identification lies with the authorities. At the same time, there is a whole series of civil society actors who can contribute substantially to the victim identification process. That is why Greta insists throughout its reports that their identification should be a multi-agency, multidisciplinary effort in order to ensure that no victim of trafficking remains unidentified. This is envisaged by the Convention, Article 10 of which talks about a collaborative process of identification between the authorities and relevant victim support organizations. So Greta considers that there should be a differentiated approach to identification, which enables a whole series of relevant actors to perform detection and identification and then provide subsequent assistance. Proper identification requires the setting up of a coherent national referral mechanism. This is a model which the OSCE has developed and promoted years ago. And we see that quite a lot of countries in Europe have set up such national identification referral mechanisms, which are a formalized sort of protocol involving a whole series of relevant actors, not just law enforcement and immigration, but social workers, medical professionals, trade unions, relevant NGOs. The list can be quite long. It depends also on the national setting. So we have seen good practices of such multi-agency identification approach in quite a few countries in Europe. You've heard already examples about from Austria, but we have that also in, for example, in the UK, where they set up a national referral mechanism in 2009. And it's interesting to know that countries that have introduced such protocols, such mechanisms, have seen the number of victims identified and referred to assistance increase. For example, in the UK, in the first 2 years of their NRM, there were about 1,500 victims detected, whereas the figures which came out last week from last year talk about 2,500 victims. So this is a proof how the involvement of a whole series of agencies and actors can increase the chances of detection. Another point which we have observed in the 35 country evaluations is that when identification is done from primarily a law enforcement or illegal immigration perspective, without the involvement of civil society actors, the chances of victims actually opening up and participating then in the investigation may decrease. I will never forget being told by law enforcement, police officers in Scotland, an example of how a victim of trafficking was repeatedly being transferred between Ireland and Scotland on a ferry. Until one day she was stopped, and instead of being taken to a police station, as normally would have been done, she was taken to a shelter run by an NGO. And it was within a day or two that the victim actually opened up, and identification was possible. What I would like to now, obviously because time is so limited, I will turn to the non-punishment provision, which is Article 26 of the Convention. At the time of the adoption of the Council of Europe Convention, this provision was the only binding provision in international law providing for the non-punishment of victims of trafficking. As you heard from Elisabeth Fisselberg, and now we have also the European Union's directive, which actually builds on the Council of Europe Convention. It came several years later, and it also has a non-punishment provision. The rationale behind this provision, I think, is quite clear. The prosecution or punishment of victims identifies them as wrongdoers, not as victims of exploitation. What is important is that this not only would contravene the state's obligation to provide assistance and protection to victims, but it also discourages them from coming forward and cooperating with the police. And in this way, it also interferes with the state's obligation to investigate and prosecute those responsible for trafficking human beings. Criminalization of victims can also lead to secondary victimization. It decreases the victim's chances at social rehabilitation and increases the likelihood of them being re-victimized and re-trafficked. So we do have provision in international law. However, the scope of the non-punishment provision is not that clear, it seems, and there are several sources of ambiguity. For example, should all crimes be covered by such an exemption, or only crimes of light or medium gravity? What if the victim of trafficking was subsequently recruited and became a trafficker, him or herself? Does the non-punishment provision also include the obligation of non-prosecution? So these were amongst the questions which were discussed last week at a workshop we organized jointly with the OSCE in Strasbourg with the participation of judges and prosecutors from 23 countries. An analysis of Greta's 35 published report shows that out of these 35 countries, at the time of evaluation, 8 countries had adopted specific legal provisions concerning the non-punishments of victims of trafficking. Since the evaluation, 4 more countries have reported that they've moved in this direction. So we have a group of countries, about a third, that have gone for a specific legal provision for victims of trafficking. The rest of the countries still rely on general defense provisions in their criminal legislation, mitigating or exonerating circumstances which are not specific to trafficking victims. So it's interesting to see also from case law where it exists, to what extent the different approaches are successful. The problem is that we have very little case law. In fact, only 7 countries in their reporting to Greta, in the information they've provided, have come up with case law related to the non-punishment principle. So we still know, there's not enough case law to see which model is actually better. But in many countries, we have received information from NGOs, lawyers, and other sources indicating that victims of trafficking are frequently punished for status-related offenses. And we note that public officials, in particular police officers, are not sufficiently trained to identify victims. For example, they fail to distinguish between a victim of trafficking and a sex worker, or between a migrant worker and a victim of trafficking for labor exploitation. So despite the existence of this provision, victims of trafficking are still imprisoned or deported. So Greta's approach at the moment is to actually propose to states to introduce a specific legal obligation. As I said, this is a trend which we see increasing in Europe, which is specific for trafficking victims and not relying on the general provisions of the criminal legislation. Simply because, well, for various reasons, but one of them is you have individuals applying the law, you have individual prosecutors and judges. And clearly from the workshop that we had last week, you can have different approaches and different understanding. And the training, of course, is essential here. The third point we agreed that I will speak about is assistance, if I still have a minute. Now, we have noticed in the 35 evaluated countries that, in general, there is need for more efforts to provide measures which are adapted to the needs of victims. Most countries have already accumulated experience when it comes female victims of trafficking, but we still have quite little experience and little assistance adapted to the needs of male victims. I can count on my fingers the number of countries where there are shelters which actually are suited for male victims. Netherlands is one such country, and Belgium as well, but most countries don't have. And in fact, countries lack specialized shelters for victims of trafficking. You know, big countries like Portugal, one shelter, etc. So there is a need also to have measures which are adapted for child victims of trafficking. Quite often they're just catered through the general child protection system. And again, this is not always adapted to the special needs of child victims of trafficking. Of course, we have to be mindful of the financial restrictions which are placed on governments in the current economic crisis climate, but at the same time, it's the ultimate responsibility of states to guarantee the provision of assistance to victims, and when it is delegated to NGOs, support providers, it is important that adequate resources are provided for that. And of course, it's very important, and it's been stressed in many of Greta's reports, that victim assistance should not depend on the readiness to cooperate in the investigation. The duration of the stay should not be limited, say, to 2 months or 3 months. It should be adapted, it should depend on the victim's real needs and the degree of reintegration and autonomy which is achieved by the victim. I will stop here because of the strict limitation on the time. I was reading a book recently which was doing a historical overview of the international law in the area of anti-trafficking, and I was amazed to see that, in fact, trafficking has been on the global political agenda for over a century now. The term which was initially used in the early 20th century was white slave trade, and then in the 1920s it turned to trafficking. The international mobilization against human trafficking has been gathering momentum over the last 15 years, in particular with the Palermo Protocol, the Council of Europe Convention, etc. And we all want to see it bear fruit. We need, in particular, strategic partnerships to improve our knowledge of trafficking and to be more effective in preventing and combating it. These partnerships should involve a whole range of actors at the international level, but also within the countries, civil society, social workers, parliamentarians, professional associations, businesses, academia, journalists. The list is really long. Thank you.
Thank you very much, and I am afraid of Canadian rage, and so I promise that I will keep my remarks 5 to 7 minutes, and thank you very much for the opportunity to be here. I know that the Swiss and Austrian governments are always amongst the leaders internationally in addressing human trafficking, and I've seen firsthand the work that they're doing on the other side of the Atlantic, and I think it's excellent that they've brought their expertise and goodwill here to Ottawa. I normally don't use speaking notes, but because I'm afraid of the restrictions, I'm going to read them. I want to talk about 2 issues with respect to victim protection and assistance. One that's already been discussed a bit, which is the non-criminalization of victims, and 2, victim compensation. And I use compensation in a general sense. I don't mean that in a particular domestic legal sense. Before we can talk about those two issues, though, of course it goes without saying that we have to know what it is we mean when we talk about human trafficking, because how you define human trafficking obviously has a correlation to who you count as a victim of human trafficking. Now, you can define human trafficking in different ways for different purposes, but the principle remains the same. You have to have a clearly articulated understanding domestically of what human trafficking is and for what purpose that definition is being used. And so, of course, the Trafficking Protocol and the Council of Europe Convention that came after that provide that starting point for countries. That is the perhaps most significant achievement of the Trafficking Protocol, which was to create a definition of human trafficking, one that for 100 years was debated. And we finally, in the Palermo Protocol, have this definition that provides the starting point for all countries, including Canada. It's easy to say that's a significant achievement and we shouldn't underestimate it. The reality is that the approach taken 15 years later demonstrates that countries are still grappling with what is human trafficking, what are some of these key issues within the definition of human trafficking. And I'd note that the Swiss government has funded the United Nations Office on Drugs and Crime to develop 3 different issues papers looking at some of those key anti-trafficking concepts, and I would urge you all to find those on the UN website. They're excellent tools. From a Canadian perspective, we have, as you've already heard, specific human trafficking offenses in our domestic laws. We define exploitation in our criminal code offenses, which is something that the protocol doesn't do. The protocol gives you a number of examples of what constitutes exploitation, but doesn't define exploitation. We define it in our domestic reality in a way that allows the courts to look at the nature of the conduct that the trafficker engages in and the context in which the accused engages in that conduct in order to determine whether exploitation has occurred. So it's a clear definition, but it requires interpretation. It requires an analysis in the context in which trafficking occurs. We have that luxury in Canada as a common law country. Other countries, civil law countries, are much more circumscribed in how they legislate. So we have a mix of statute-based law and common law. That's our approach to human trafficking, and I'll just quickly turn to compensation. It's an issue of ongoing international concern. It's been the subject of work within the OSCE, within the Council of Europe, within the United Nations, amongst the community, non-governmental organizations as well. And it has as its starting point two places, Article 6 of the Trafficking Protocol, and in the European context, Article 15 of the Council of Europe Convention. States parties who have ratified those treaties are required to provide compensation, access to compensation in their domestic law. So we have seen different approaches taken in different countries to implement those requirements. In many cases, restitution is the model that is employed, whereby the offender, upon conviction, provides financial redress or compensation to the victim for the losses that are identifiable as a result of their victimization. In some jurisdictions, there are rights of civil action, a tort. You can sue the offender for human trafficking. And you also have to think more broadly beyond the criminal law context and look at administrative proceedings. So things like labor rights infractions, or labor boards or human rights boards, which can provide or order compensation to individuals who have had their rights infringed. So there's a bit of a spectrum there in terms of criminal law remedies, civil remedies, administrative remedies. And then, of course, there's state-administered compensation schemes. A lot of those schemes are funded through fines that are ordered to be paid by offenders, and those compensation schemes are then used to provide some limited redress to victims. Now, each of those approaches will have advantages and disadvantages. In most cases, the big problem is that victims can't access that money. They have the ability to claim it, courts may order it, but in large measure, they're not receiving the compensation because offenders aren't paying, because there isn't enough in the systems that are administered. And so it raises a number of practical challenges in terms of how meaningful those rights are and the ability to provide recovery to those victims. I have talked about this before. The OSCE has talked about it, as has the UN Special Rapporteur on Trafficking, as a possible model looking at seized assets, proceeds of crime, as a way to directly compensate victims of trafficking. The last time I looked at this, was not aware of any country that has gone in that direction. And if there has been some recent movement, it would be quite new. The immediate advantage of that is it provides the state machinery as the vehicle for accessing the money for the victim. It takes the responsibility out of the hands of the victim. The state is required to do it, and the proceeds of crime that are seized are transferred to the victim to compensate them for their losses. And of course, that begs the question, and it's already been talked about by the ambassador, the state, the law enforcement community has to initiate those proceeds proceedings. We have to seize the assets and we have to have them ordered. And we're just not seeing uptake on that internationally in the way that should be. And so that is an area that I think remains underutilized and in need of significant focus. I'll just note two very quick things in Canada. One that's already been talked about, Bill C-32, which is a bill before Parliament right now that is an act to enact a Canadian Victims' Bill of Rights, would amend our restitution provisions to allow, to require, judges in all cases to consider making restitution. So generally speaking, under the current state of law, judges can consider it if a prosecutor makes the application, but there's no positive obligation on the court to consider it in all cases, which will be something different under our new laws. And then I'll just note, because we're a federalist state, our provincial governments have also taken steps to address human trafficking. And in Manitoba, a number of years ago, they created a tort of human trafficking, which is unique in Canada, to provide a civil mechanism for victims to sue their traffickers. I'm just going, do I have 2 minutes? I have 1 minute. Non-criminalization, my colleagues already talked about it, so I won't get into it, but I will say this. It's easy to say we shouldn't criminalize victims of trafficking for criminal activity that they engaged in as a direct result of their being victimized. But in practice, that is extremely difficult to implement. There are any number of examples, one which was talked about, the person who has been exploited, who's promised if they recruit 5 new people that they don't have to be exploited anymore. They know that the 5 people that they're going to recruit are going to be subjected to sexual or labor exploitation. It's not easy to say in all cases those individuals should not be charged or prosecuted. So what I think is critically important is that governments, prosecuting authorities, law enforcement agencies turn their mind to those issues and develop protocols, policies, legislation, whatever's required, so that when they're faced with those cases, they know what the answer is. What's their approach going to be in those cases? It's not easy to create rules that will address every situation, every possible permutation, but it's critically important that we do so. And from a Canadian perspective, as part of our ongoing work to train our justice system, we're constantly reminding police officers and prosecutors of this issue, and that before making a decision to charge, that they need to step back and have a conversation and determine whether it's in the best interests of justice and, of course, the best interests of the victim to move forward with a charge or a prosecution. And I will conclude there. Thank you.
like to thank the organizers of this very important event. It's great to be here. The presentation today, my presentation, is based on the findings of an article I recently co-authored, and which will be very soon published in an international peer-reviewed journal. What we did with my co-author is comparative analysis. Canada and some European countries, and we use a lot Greta reports. And the article explores the intersection between human rights law, criminal law, international and national, and refugee law, and which shows the complexity of human trafficking as a phenomenon. So my presentation today is on the non-nationals, victims of trafficking, foreigners, who have specific vulnerability and protection needs. I have 4 slides, 7 minutes. I'd like to highlight only 3 problems in terms of the protection of trafficked persons in Canada and also in Europe. The first problem I'd like to highlight is the gap between increasing number of human trafficking victims and the number of prosecutions and convictions. This is a point already mentioned by the previous speakers that I'd like to highlight because it's extremely important in terms of deterrence. One of the aims of the criminal justice system is deterrence, and when you look at this gap, huge gap between increasing number of human trafficking victims and the number of prosecutions, be it in Canada, or the European Union or Council of Europe member states, and I included some statistics here. There is a problem in terms of deterrence, which creates, I know it's a bit dramatic, to describe the situation as a climate of impunity, but when you look at this gap between the numbers and the number of prosecutions and convictions, there's a problem of deterrence and a climate of impunity created. Especially, there's also a problem of gap between the maximum penalties foreseen in the national legislations of different countries and the sentencing decisions. So again, a problem of deterrence. The gap, these 2 gaps I highlighted are due to a number of factors, and some of them have been already mentioned by the previous speakers. And I have a list here. It's not an exhaustive list at all. It's due to the trafficked person's vulnerability, but also it's due to the inefficiency or problems with the criminal justice system. In Canada, but also in different European countries, we see the similar problems. So at the level of the trafficked persons, they have a fear of criminal charges and deportation, and this is really a vulnerability related to foreign non-citizen trafficked persons, the lack of information on their rights, especially when they don't speak the language of the country, and reluctance to testify against their traffickers. There may be mental health issues, post-traumatic stress disorder issues, etc., which may explain all these problems in terms of trafficked persons, participation into the criminal justice system to help the system prosecute and convict human traffickers. But also there are sets of problems related to the criminal justice system, especially the recent nature of the offense of trafficking in Canada and other in European countries as well. There is a lack of established case law at the highest level. We don't yet have a decision from Supreme Court, for example, defining what is trafficking, how it should be implemented in the domestic law, etc. Underuse of the offense of trafficking is another problem, which brings me to a main issue I had when I drafted this article, the lack of reliable statistics. It's a huge challenge to get the statistics including in Canada. And within Council of Europe, Greta does really a great job in terms of knowing what are the problems. And without these statistics, without these figures, we don't have a clearer idea on the problems, and we can't address the issues appropriately. Another problem is the adequate resources and personnel, monitor labor conditions, proactively identifying human trafficking victims, already mentioned, and for criminal justice agents engage in cross-border cooperation, including joint investigations, could be very important, but they don't have adequate resources or training or personnel. The second problem I'd like to highlight is the lack of a human rights-centered approach. When you read the recent decisions from different tribunals in Canada, especially I would refer to the Motor case, you clearly see the lack of human rights-centered approach. It is really focused on how the system functions, how the system was abused by the human traffickers, but the human rights or special protection needs of trafficked victims are really neglected by our decision makers. The example I'd like to give very quickly is the recovery and reflection period. I know that this is something that will be dealt with the next panel, I guess. But recovery and reflection period, how it is implemented, also reflect this lack of human rights-centered approach in terms of fighting human trafficking. The length, UNODC suggests 90 days. In UK, it's only 45 days. In Canada, well, we have a more human rights-centered approach. But when you look at the number of temporary residence permits, they are really very low, especially when you consider the increasing number of human trafficking victims. Victims compelled to testify against their traffickers. That's a problem already mentioned. And there are also some systemic problems in terms of the implementation of recovery and reflection period, such as the lack of knowledge by law enforcement authorities or service providers, which makes it very problematic for human trafficking victims to access to this very important measure, which is the recovery reflection period. My last point is more on refugee status, and the point I'd like to make is a major misunderstanding by the criminal justice system actors of what human trafficking is and how it should be implemented. I totally agree that there were very important developments, positive developments in Canada and in other countries as well, but there is still this misunderstanding about the human trafficking, and I think the refugee access to the refugee status shows it very clearly. As you may know, the trafficking victims may have a well-founded fear of persecution, so they may get the refugee status. And we have a developing case law in Canada, in other countries as well. Yes. But there are fundamental problems in decision-making. Again, when the human trafficking victim is smuggled or involved in criminal activities such as prostitution, or when the victim finds him or herself in an irregular situation, the victim, this person, is considered as criminal or victim of criminality rather than victim of persecution. So what the decision maker says, you are not a refugee, you're just a victim of criminality, you're not persecuted, you don't have a well-founded fear of persecution, and the claim will be rejected. Another problem is a trafficked person may be defined a member of a particular social group, so may satisfy one of the 5 grounds of persecution defined in the 1951 convention, UN Convention. But when we look at the implementation of these criteria in Canada and other countries in Europe, we see that the case law is based on inconsistent and unclear criteria. decision maker has a huge amount of discretion and narrow and gendered interpretation. When you read the decisions, the human trafficking victims who are considered a member of a particular social group, thus a refugee, are perceived as young, inexperienced, often uneducated, and forced or duped into sex work. So the last thing I'd like to underline is the a total misunderstanding, misconception of human trafficking, especially when you consider that increasing number of human trafficking victims are men, are in forced labor and not in forced in sex work. So thank you so much for your attention.
So thank you for having me and for letting me share a project from PACT Ottawa. So what was already mentioned, PACT Ottawa stands for Persons Against the Crime of Trafficking in Humans. We are a nonprofit organization that was founded in 2004, and it's a secular organization mostly based from volunteer work. And our focus is really about education and public awareness initiatives around human trafficking. And we focus on organ labor and sexual exploitation. So what I'm going to be talking about is Project Impact. PACT Ottawa received funding of $200,000 from Status of Women Canada in the June of last year. And it was to conduct a pilot project on human trafficking for sexual exploitation in Ottawa. And the focus was girls and women. So the way we conducted it, we had a steering committee consisting of the Ottawa Police Services, Crime Prevention Ottawa, and St. Joe's Centre. Since there is limited literature out there, we had to do a lot of the data collection ourselves. So we went out and we conducted a lot of interviews. So what we did is we held 3 roundtables and online surveys with 34 community stakeholders. And we also did dedicated 2-hour interviews with 27 key informants. We held focus groups and interviews with 90 youth and 10 self-identified sex workers. So the organizations varied from, they were social workers, youth organizations, victims, as well as survivors of human trafficking, immigration services, Aboriginal services, and we even interviewed a former trafficker. So just to give you a general sense of what we found, before I go into the barriers, we found that actually for the Ottawa area, the research indicated that 90% of girls that are being trafficked in the area are actually Canadian or from the local area. Now, this, not to say that there aren't international victims, but from what the research that we conducted, we found that 90% are Canadian or Ottawa area, and this was quite a surprise to a lot of people. We did find that there is no real consistency amongst what the demographic is. So we had victims from different race, religion, socioeconomic backgrounds, and even sexual orientation. The average age was between 12 and 25 that were first trafficked. So to look at the age range, I don't know if hopefully you can read it, we found that we heard of victims at the age of 9 to over 40. And as you can see here, we define youth between the age of 12 and 25. So the majority of them are between that age. And you'll see a peak between 19 and 18 because a lot of the victims that were trafficked the first time were actually 15 to 16. So that's why you'll see a peak there. The women and girls, as I had mentioned, they came from all kinds of backgrounds. So what usually would happen is youth would be the most vulnerable group, but it intersected with some kind of other vulnerability. So they experienced some kind of neglect at home, there was poverty, maybe there was drug use, they were in a group home, there was maybe a history of sexual abuse, or as other panelists already explained, mental health issues and so on. We found that sometimes they were runaways, homeless. We found a lot, or a big vulnerability, which hasn't been mentioned that much before, was the LGBT community. And that was because we found that 40% of homeless youth identify as LGBTQ. And so because of this, it makes that community that much more vulnerable. So some of the barriers. This is hard to read, so I have another slide, but if you think of it as a circular motion for next slide. So it starts off with, and that was hard to define, but I mean there's demand, it's lucrative, there are systemic issues as to why human trafficking exists, and we'll go into that. But the second step is really about, there's a lack of prevention initiatives or identifying women or girls that are at risk. So generally what we found, there is a lack of knowledge around the term of human trafficking. On behalf of the victim and social workers or people working within and coming into victims of human trafficking. And most of the time it was really being conflated or misunderstood with the issue of smuggling. So just the term in itself was something that was confusing just generally to the public and victims. And because of that, also victims didn't always self-identify as human trafficking. They may have called it something else, but the term itself is not something that they really understood. Then the process of recruitment was happening, or physical or mental conditioning, so we call grooming. And we heard this happen over a 3 to 6 month process. And this added to the fact that a lot of the victims didn't self-identify as human trafficking victims. So it wasn't the fact that they were being kidnapped or anything like that. It was actually psychological grooming over many months, which again made it very hard for them to self-identify or to be identified. And at the same time, it added to the fact that then they wouldn't testify against a trafficker because they didn't always identify him or her as a trafficker. Then the manipulation and exploitation happened. Sometimes this sort of was a gradual process, and that was most of the time, but there was also sometimes a violent act that was happening. So it went from maybe a boyfriend situation to then a rape or a gang rape or something like that. Well, sometimes it was a gradual, do me a favor, sort of those kinds of situations. And then what would happen, there would be some kind of trauma incident. And then the victim would come in contact with either a hospital worker, a social worker, or be in a shelter, or be arrested. So that's how they would all of a sudden then come into contact with the public system. And then the seventh step was they were not identified. So most of the times they weren't really seen as victims, or they were falsely arrested. We heard that a lot with regards to drug possessions. So sometimes they were arrested and charged under something else and not identified as a victim. They weren't self-identifying and they were not being identified as such. Also, we heard of a lot of humiliation that was kind of happening. So if they went to a shelter or in a hospital, they would usually be identified as a sex worker, and then there would be a lot of stigma around that. So instead of being identified as a victim, they're being identified as a sex worker, and subsequently are getting a lot of stigma around what they're doing. And then what would happen would be the final act and would go back into the circle of, then they would be released without any assistance. So there is no identification or anything like that. They wouldn't know where to go, so they go back right into the thing. They go running back, in a sense, to what they know, or the only thing that they somehow feel is, has given them a safe home. I'm about to wrap up, so it's good timing. So what we're doing for Project Impact, so the first year was really about the research, and the second year is about implementing the recommendations that we have. So we have short-term and long-term goals, but the short-term goals, what we're going to be doing is training frontline staff. So the Ottawa Coalition to End Human Trafficking is already doing this, so working with them very closely to update some of the training that's happening so the frontline workers can identify human trafficking victims. We're also going to be talking to youth because they are the highest risk, and so that's going into schools and group homes and talking to them about what is human trafficking, how can you identify it, and making a distinction between this is human trafficking, this is smuggling, and it can happen here. And that adds to sort of the public awareness too, but we're going to be going into shelters too and putting up posters and just information. And then we're going to continue to do outreach and work with sex workers that have a lot of insight into difficulties of the situation. And we have the report. It's free. I only have this one hard copy, but it's online. So if you wanted to read more about this, you're welcome to download it and get some more information. Thank you.
Thank you very much to all the panelists for more or less sticking to time. And that means that we have about half an hour to ask questions and have a conversation amongst ourselves. So like the last panel, I'll ask people to stand up at the microphones and to ask their questions. You are welcome to direct them to a particular individual or to the panel in general. Look at the speaker awkwardly.
Okay, sorry. My name is Christine Straley. I'm at the Graduate School of Public and International Affairs. I have a question for Matthew. Thanks for your presentation. I thought that was very interesting and very helpful. You were talking about compensation, and obviously we can imagine very different scenarios for different trafficking victims. We can imagine somebody who has been trafficked for a very long time, or somebody who has been in a short period in a country. And I was wondering if there is any thinking about the kind of standards of compensation. So are we accounting for time? Are we accounting for trauma? Are we accounting for the kind of work people had to do? If it's sexual work, it is more harmful than if it is agricultural work? Or is the simple idea that if you're trafficked, some violation has occurred, and that violation is the basis for our compensation? Thank you.
Thank you for the question, and I'll start, but I'm sure others will have something to say as well. I think it fundamentally depends on the compensation model that one uses, or one that's talking, that's at issue. If we look at the restitution framework in domestic criminal law, it's very specific, the types of things that can be financially compensated for, so physical loss of employment, loss of things, and so when you think about the trafficking context, it can be difficult to quantify the ascertainable loss in a restitution scheme. The U.S. has an interesting approach that they've employed in their restitution context in creating a formula for estimating the amount of money that has been earned by a trafficked person if one cannot otherwise quantify the loss. So that's one model. In a civil model, there might be opportunity to compensate for pain and suffering, psychological harm, things of that nature. So I think it ultimately will depend on the model that's employed, and of course the particular circumstances of the victim at issue.
If we have time, I would like to add something on the issue of compensation, because it's obviously very important, and the previous panel touched upon the importance of seizing the assets of perpetrators, but of course we know that this is still not happening that frequently, and we have an overview of what the 35 countries that I previously spoke about are doing in the area of compensation. We see that there are very few successful compensations from perpetrators. That's why state compensation schemes are so important. Some countries, I can quote the Netherlands and Iceland, for example, in Europe, they have set up a system whereby the state would advance compensation And then subsequently it will be the state that will be after the trafficker's money. So in a way it relieves the trafficked person from going through what can be a lengthy and painful process of claiming compensation, which can take years, and then if the trafficker is never caught or convicted, is bound to fail.
I'm with Sunlight Financial. I'm in the business of protecting what is most valuable to all of us, which people who've been sick know, it's health. I've always worked in areas related to health. I did an internship with the International Organization for Immigration in Moscow, and something that was extremely valuable to me at that time and something that I was looking forward to learn more about is how statistics on the health of trafficked people is used in protecting them. Because, for instance, like I tell people, 1 in 4 people would be diagnosed with cancer. Let's work a solution. And I know in Moscow, out of these centers for trafficked people, because there were a lot of people that were rescued and treated, there were statistics to say women trafficked into the sex trade are carriers of sexually transmitted illnesses. In addition to trauma, there were like sexually transmitted disease, TB, and that for me at that time was like striking information. It's like, this is an information, it's valuable, like it's linked to public health. It is of importance to all of us. Because you see now with Ebola, it's an illness that is like threatening everybody, and so everybody is reacting. And so I was really curious to see how health information is being used in Europe and in Canada. I know in Canada like there's strict laws for protecting private information, but it's not the case everywhere. And especially, like I can give an example, in France, there's like hundreds of thousands of illegal people who have access to the healthcare system. It's all free. And like people are treated, so anyone can comment on protecting the health of, and how that information is actually used to inform policy, to engage community, to like make it a public issue where like we're all responsible. We can be affected because the users of the Canadian girls trafficked in Ottawa, the users are like people who may be like down the street, and they could be a carrier of a sexually transmitted disease. So anyone would like to comment? Thank you.
Thank you for the question. I think it's a very important point that you raised. The information about the health needs or in terms of access to healthcare of trafficked persons is I think it's very important, and this is one thing, and I think there are measures that have to be taken by our authorities in terms of recognizing their vulnerabilities and their specific needs in terms of access and also effective implementation of healthcare measures. This is one thing. The other thing that you mentioned, the information which is available about the health problems. I think, I'm a criminologist, so I'm a bias. It shouldn't be used as in creating a moral panic about human trafficking victims either. So I take your points are concerning the protection of personal information is very important. The dignity of human trafficking victims is very important, but I will refer to the criminalization of human trafficking, and it's also very important to make sure that this information is not used in order to create a moral panic or or to criminalize further human trafficking victims, especially when you take into consideration the fact that in Canada, the majority of human trafficking victims are Aboriginal women. So it's already a victimized population, or it's also about the foreigners, irregular migrants, or people in a very delicate migration status. Yeah, there are two aspects which are very important in terms of addressing their vulnerabilities and also their specific needs in terms of healthcare.
Yeah, I just wanted to add to that. When we were doing the research, we were also looking at the cost element and what is it costing the public, not to stigmatize one population more, but just to see what is the cost of this. It was very difficult to find research on that. I felt when I did find research, it was mostly European-based, so I feel like in Europe, especially in England, more of that is being done, especially also by the government. Here in Canada, it's not. I couldn't find anything in that regard. So it was just a general. What are the health factors of trauma or sexual exploitation, but not specifically for human trafficking victims. So I think it's certainly something that would be necessary and important to do.
Sure, just a couple of things to add. I know, and perhaps Elise was talking about this research, Kathy Zimmerman from the London School of Tropical Medicine has done a fair amount of research on the health implications of human trafficking, both I think independently and in conjunction with the World Health Organization, and how health considerations have to factor into anti-trafficking policies. I'm not aware of any domestic research either on this issue. You know, I think in Canada, one of the advantages that we do have is a generous social system in terms of access to universal health care. For foreign national victims, our temporary resident permit entitles those victims who wouldn't otherwise qualify for provincial health benefits to access our federal interim federal health, in addition to kind of essential medical care that would address dental and counseling as well. And that provides a bit of a stopgap, a buffer between when those individuals are ineligible for provincial health benefits and when they do become eligible. But you're absolutely right. I mean, I think the health consequences of human trafficking can be significant, and it has to factor into the development of policy.
Hi, my name is Bethlehem, and I am from the office of Wayne Marston. My question is directed to Elise, if that's okay. You mentioned that 90% of the people that are targeted with human trafficking in Ottawa are Canadian, but from different backgrounds. But I was wondering if is there a certain background that is targeted most by within that 90%? Because understanding their background will help or would help in providing the right kind of assistance. And the second question is, what kind of organizations do you work with trying to provide assistance for the victims? Thank you.
If I understand correctly, the 90%, yes, what we found and what was surprising to the community and when we shared the research is that they are Canadian or domestic. And the backgrounds were varied. I mean, and that's usually because there was an intersectionality. So yes, they were youth, and that was the majority of victims, but it intersected with some kind of other vulnerability. And those really varied. So just from the interviews that we conducted, the majority of times what really came out was the fact that they were youth. And then there was homelessness, or there was some instability at home where they were in a group home. So that was probably the most, and that affects different populations in different ways. And with regards to the 10%, that was because we couldn't fully identify who the other 10 were. So in some cases, these social workers or the police or whoever we were talking to, it was unclear by the information that they were giving us who they were. And so that's why we the 10% was the unclear kind of part. Not to say that there aren't international human trafficking victims, because it could be just as to the people that we were talking to, the social workers, or they were already in contact with the system that is available. But what about those trafficking victims that are probably not in contact with the police or social workers because there's language barriers, they don't know the services that are available. So that is a group we don't know about. They could be even, these are the ones we should be worried about if they're out there. So that's really difficult to define. And the second question was about who we worked with, who we're continuing to work with. It really was across the board. So we do work with the Ottawa Police, but we worked with a lot of shelters and social organizations. So we work with YSB. We do work with, we're continuing to work with Pink Triangle now to try to address the LGBT community. We're working with shelters. And we're working with high schools, and we're working with group homes. So it's really across the board of where we could potentially find human trafficking victims and who are really in contact or where they might be. So.
George Jacoby, former diplomat. I missed most of the discussion, but I was just interested in what the panelists might think of the new anti-prostitution law, which has passed Parliament and billed as an anti-trafficking assistance to victims bill, in part of its rationale at least. Do you think that this will sort of the criminalization of the purchase of, but not the sale of, but certain other activities related to sexual transactions. Do you think this bill will help or hurt victims of anti-trafficking, and is it a wise bill to implement? It's now passed the House of Commons.
Can I actually add to that question to ask Petya if she's able to comment more generally on the different strategies that European countries have used with respect to prostitution, because prostitution is legal in some countries and not in others, so that might help us understand how we should respond to this bill.
Well, I guess I'm on the hot chair now. Well, as you can imagine, in Europe this is a hotly debated issue, and within the Council of Europe there was recently a report by a Portuguese MP, Mendes Bota, who spent some time researching the linkages between prostitution and trafficking, and he did research in several countries in Europe. I think even the report mentions Canada, if I'm not wrong, but anyway. So this is a recent report, and obviously it is just one piece of an ongoing debate. I was very recently with Greta in Finland in June, and there for the last few years they have been researching, working groups, debating, etc., and there's no consensus whether to adopt the Swedish model, and they're not going in that direction at the moment. But of course other countries, as we know in Europe, have adopted the so-called Swedish model. Norway and Iceland are such countries. In France, where I live, where the Council of Europe is based, for the last 2 years, it's been, as you probably know, very, very present, this debate, and for the moment it is in the Senate, I think, and I think there are the priorities in France at the moment. Anyway, this is a long story. To cut it short, I'll just refer to what Greta has said in some of its reports, in particular countries where the criminalization of the client has taken place. Basically, Greta thinks that one should have a cautious approach to this, to the extent that any policies, any legislation which is passed in this area should not be to the detriment of the victim. So everything should be kept under very close scrutiny and close review. And if there is indication that legislation criminalizing the client is to the detriment of the victim, that victims go underground, that they're more vulnerable, more abused, that they're not identified, etc., etc., as some research suggests, then obviously this should be kept under review. So I think in Norway very recently they did a review of the first few years of the functioning of their ban on criminalization of the client. It was, I think, published very, very recently, so I haven't even had the chance to read it. But that's what it should be done. I mean, if Canada has taken this road, this decision, clearly you should keep it under review and scrutiny. I have heard fears in countries where they have very limited resources for policing, that if the police officers start prioritizing, well, I mean, if they're, obviously police officers are given priorities, and they can't probably deal with everything with the same order of priority. If the priority would be clearly given to them that they should be going after the clients, will they be going after the traffickers? Is a question that can be put and has been put. And here I want to go back to, someone asked earlier, what works and what doesn't work. Well, I think what works and what we see that works is when you have specialization of police officers, prosecutors and judges, as we see in some countries. And where you have, and labor inspectors, of course, where you have really dedicated units, specialized units, trained, as I said, dedicated, you get more identifications, you get more convictions of traffickers. So specialization and dedicated structures are very important.
It's a bit difficult for me to offer you my personal views on a piece of legislation that my department is responsible for advising the government on. But I guess what I would say is just to echo the point that in all countries that have looked at this issue, there continues to be a lack of consensus on what the most appropriate criminal law response to prostitution is. I don't think there's any indication that reality is going to change in the future. I agree with all of the points that have been made. I think if you look closely at the research, you'll find research to support whatever position is a position that's important to you personally, or to your organization, or to policymakers. I'd also I'd point out two other things. Bill C-36 does propose some amendments to human trafficking specific offenses in the criminal code. So there are some human trafficking reforms in that piece of legislation. And the other thing I'd encourage you to look at is a technical paper bibliography that our department has prepared, summarizing, providing information on the research that we relied upon, or the government relied upon, in informing its policy decision to approach prostitution the way it has.
Are there other questions among the crowd? Then let me take this opportunity to ask Adil one additional question about, you had a slide up there indicating that I think you were advocating that we should take a human rights approach to the crime of human trafficking, and I actually wondered if you could say just a little bit more about what that might entail. For example, what are the rights of the victims of trafficking that you think that we should emphasize in particular, and in general, how you think that sort of framework might structure any kind of response that we should aim to implement?
Yeah, thank you for the question. I think the solutions have been already mentioned in the previous panel and in this panel as well. The reason why we looked at the Council of Europe countries' implementation of the Council of Europe Human Trafficking Convention was that this convention has been elaborated, and I remember it very well because I was working for Turkish permanent representation at that time. And I've been involved in the first two preparatory meetings between experts from different countries of the Council of Europe. It was a kind of reaction to the UN trafficking protocol, The Council of Europe Committee of Ministers decided to take a human rights-based approach, more centered on human trafficking victims' rights and freedoms. So we wanted to see what are the differences of implementation between Canada and these European countries which are implementing this human rights-based convention. And we couldn't see much difference. We were really disappointed. Human rights-based approach is taking the human trafficking victim as the center of the problem, and once the problem had been identified, and we provided a list of these problems, prosecution, conviction, problems with the criminal justice system, the trafficking victims' specific vulnerability, his or her legal status, etc., etc., then we have to tailor specific measures addressing these problems. But the victim should be at the center, and not the system, or criminal justice system, or the state's territorial sovereignty, or its borders integrity, or the social assistance programs integrity, which was the case in the Domator case, which are threatened by the human trafficking phenomenon. I don't think this is a good approach. The good approach is to look at what are the needs of the human trafficking victim and try to address them. And as I said, we already mentioned many of these solutions.
Are there other questions?
I'll try to make this quick. My name is Michelle Meyer-Sarrazin. I currently work at the House of Commons as a parliamentary assistant. It's probably more related to PACT's work, but I'm curious about the work that's done to assist with reintegration, particularly regarding Aboriginal women. So a lot of the victims in Ottawa particularly, but around, are either First Nations or Inuit women. And is there any culturally appropriate, or the difficulty of coming from an already poor and often stigmatized area, being here in Ottawa or in other big cities, and trying to help with the reintegration and adaptation after they come out of trafficking? Thank you.
I'll try and answer that, but PACT Ottawa is not service-oriented or not providing services, so I'll try and but still give you some insight from the research that we're doing. Certainly what we found working with the Aboriginal services that are here in Ottawa is that a lot of the Aboriginal women or girls were coming down from the north looking for sort of a better or more opportunities. And that's a vulnerability in itself, coming down here and not really having a base, a social base. And then because of that, they're easily exploitative or vulnerable to being trafficked because they don't know the services that are available or even where to go to, and most of the time they're homeless. So what we found from the services that are existing, it was really hard to reach some of these women. So they know they were out there, but they didn't really know how to come in contact with them. So for instance, we were talking to Minwashin Lodge, and they are doing a lot of outreach, I think three nights a week. And again, they were like, we know that there are victims out there, we just don't know how to reach them. So it's certainly even harder because of the added vulnerability they have of coming from another community and so on. So I hope that sort of answers your question.
I think that we'll take this final question. Thanks.
Is this working? Okay. I just wanted to, I tried to wait till the end just to add some additional resources to a couple of the questions that were mentioned in this panel. Christine, I just shared with her, there's a report of the OSCE ODIHR on compensation for trafficked persons. And also there's an NGO project in Europe, including the Austrian NGO LEFO, called Compact, and it's, I think, compact.org. And you can find a lot of case studies on compensation that's going on, including Austria, since we're here under the auspices of Austria and Switzerland. And then on the health side, I would recommend also that you do some research online, but I mentioned 2 publications this morning you should look at from our office. One is on the clinical study relating to trauma and victims and sexual exploitation done by the by our office with the Helen Bamber Foundation in London. The other one's on trafficking for organ removal, and that also has a lot on medical ethics and how the health community is involved in this, where the legal and illegal communities come together on this issue, and it's very interesting. IOM has a handbook on health for health workers on this issue, and we are interested in training medical workers more in the future, and I know OSCE has done this. I think also HHS in the US has worked a lot with healthcare providers, so there's a lot of information out there, and in addition to what Matt mentioned at the London School of Hygiene. So just there's a lot out there, just to mention a few resources.
Great, thank you very much. And now I'd just like to invite everybody in the room to join me in thanking our 4 contributors to this panel, and then to invite everybody to enjoy an opportunity to eat some optimistically tasty lunch, and certainly to enjoy some good conversation. Thank you.